thought that the program materials that you picked up at the front desk, wait till you hear me talk for a couple of minutes. And, but while you're sitting here, I'd like you to review the program materials carefully, because the last hour of the program is an essay exam, since we are here in law school. So, and we'll leave the door open for a little while. I think that the food and drink will be there, so you can feel free to come in and out. But if you could just leave the tomatoes in the back there, I'd appreciate that. So it's so nice to see so many people gather together in one place for a discussion of what is now called corporate oppression. Corporate oppression has grown statutorily and in the common law from the concept of a business fiduciary duty amongst originally partners, joint adventurers, and it's expanded over the years to encompass those with special positions of power within a business enterprise. Now it's grown into a statutory cause of action here in Michigan, the landscape of which has recently been reconfigured in certain respects by the Michigan Supreme Court in the cases of Frank and Matagula, and more recently in the Court of Appeals case of, and just so we can always be confused when we're talking about it, Franks as opposed to Frank being the other case. Franks v. Franks. I had the opportunity to write briefs on these cases with my law partner Brian Sachs, who's here tonight, and he'll be running the IT over there. So I find it very intriguing to watch how these, some of the first published precedents in recent years are being applied in the trial courts. So I was really excited when I saw the roster of lawyers who signed up to come tonight. There's a lot of good business lawyers in the audience, several of whom could easily get up here and speak, at least in the place of me. I don't know about the rest of them. But because of that, we absolutely encourage audience participation, and Linda will be over there with a mic. If anybody has a question or wants to chime in and really be heard, we can get the mic over there. So I find that that makes these discussions most interesting when there's some interaction. So on behalf of the State Bar, I'd like to thank Wayne State University Law School, my alma mater, for allowing us to run the program here, the Wayne Business Law Journal, and in particular Joe Zanetti, the journalist co-hosting the program, and has helped promote it through the law school, so we really appreciate that. Mary Hiller, who helped us market it throughout the law school, the IT department, who got this all set up, Chris Browning, who I call the Dean of Career Services, and Aaron Mack for the food. So what is a fiduciary duty really? Well, I like to go straight to the source, to Justice Benjamin N. Cardozo. Oops, I forgot to change this. There he is, Benjamin Cardozo. Judge Cardozo, in 1928, he was the chief judge of the New York Court of Appeals before he succeeded to Oliver Wendell Holmes' seat on the United States Supreme Court in 1932. And I believe definitely this man is smiling down here tonight on our symposium, because we're talking about something that is really grows out of a concept that he penned so articulately in 1928 in the case of Meinhardt versus Sam. Now, I think that this is the most articulate, penetrating, and actually frightening standard in the law. It's beautiful and frightening, like a lot of things in this world. And if you read the language, and this is old stuff, it's not in the statute, but it's adopted by Michigan Supreme Court precedent, and most courts throughout the land recognize this as a great description of a fiduciary obligation. And I'm not going to read it to you, but I'll leave it up there for a little while. And there's more. So why should this have every fiduciary shaking? Because what it means is that workaday conduct is not okay. It's not good enough. Arm's length conduct is forbidden. Honesty, and remember when you were taught honesty was the best policy? Not here, because in this language here, it's mere honesty alone is insufficient. What Justice Cardozo, of course throughout the land hold business fiduciaries to, is the punctilio of the honor, the most sensitive. And that becomes the standard of behavior. And then, just when a fiduciary thinks he or she may be able to comply with this standard, our fiduciary learns that the tradition is unbending and inveterate with an uncompromising rigidity. So in case you were unclear, what it is, fiduciary obligation is a level higher than that trodden by the crowd. It's higher than an arm's length business transaction. It's different and it's special. Oops, he's not, okay. And what it means in practice, I've found, because this principle does find its way into the case law, interpreting the statute, in practice, it makes it very difficult for a fiduciary defendant to get a case dismissed once it's filed. It's not exactly clear everything that constitutes a fiduciary duty. And things that one might view as relatively minor or unimportant, like not responding to a statutory demand for documents, in native format, can actually constitute an act of oppression under the Madagula v. Taub standard. Full disclosure, without full disclosure of things that a fiduciary may feel are immaterial, that can constitute a breach of fiduciary duty. The consequences are severe because the lawsuits can cause a company to come to a grinding halt. For example, if it's taken over by a court-ordered receiver. And you'll hear Dan Quick argue in a little while that it's gone a bit too far, as my mom used to say, and the application of the statute should be reined in. I respectfully disagree, but we're all about free speech here. So I hope you've all had a chance to go through the not-so-brief fact pattern, which, like I said, itself is a portrait of oppression. But I just, does anybody know who wrote that? It was really absurd how long it was. So, but it gives us a little bit of a basis to discuss some facts and maybe entertain ourselves just a little bit here. But that fact pattern, it really mirrors the absolute madness and the fear, the greed, the loathing, and the shenanigans which we see recurring over and over in these shareholder cases. Fraud, embezzlement, withholding distributions, starving out the minority owner, capital calls that shareholders can't afford, triggering forfeiture of shares, self-dealing, corporate usurpation. It's all great stuff, and we'll discuss a lot of things that actually, a lot of those things, although they fly in the workaday world, they can actually trigger liability and oppression lawsuits. Like, for example, in the Franks v. Franks case. And in that case, there was a question in the trial court as to whether the majority controlling faction could not share valuations that they had, in which they were using to negotiate a buyout with the majority shareholders. And on those facts, the trial court in St. Joseph County ordered a buyout of over $20 million, give or take. And it was interesting, there was a line in that opinion that the court cited the Court of Appeals in reversing that case. And the Court of Appeals wrote, they called it a drastic remedy to force the buyout of those shares at a price and over a term that threatens the viability of the business, clearly implicates the interests of innocent third parties. And that's important because I think that courts and lawyers should, on both sides of the equation, consider the collateral damage that these cases have on businesses and the economy in general. And I think that feeds some of the policy arguments that we hear made in favor of a broadened statute or a constricted statute. So in a way, it's like a divorce with these innocent third parties involved. And we have the Madagula case clarifying that these are not jury trials. These are judge trials, bench trials. And judges sit in equity and they'll craft their decisions. Again, not unlike a consent judgment of divorce where you're separating two parties and there's all kinds of tax implications and separation of assets and things of that nature. But at the same time, and this is where we see the tension arising, the judiciary should be disinclined to award a windfall to a wrongdoer. Why should a controlling partner be permitted to benefit from his or her wrongdoing and have the company valued at the date, for example, after it's been completely devalued by that person's conduct? So you got to rewind the clock a little bit. And I think that's what the Madagula court was getting at when it held that this wasn't a situation for a jury to resolve. So there's a fine line on these issues, on the question of what is oppression. Hopefully you don't leave more confused than enlightened, as I often am after reading and trying to apply some of these precedents. But I hope that you'll leave with some tools that will help you advise your clients in these regards and prosecute and defend against the claims when they arise. So first we'll hear from Professor Douglas Mall, who traveled up here from the University of Houston Law Center. It's an honor to have him here, and I've cited his work often, and it's really good stuff and worth a read. I'll send out a link tomorrow to everybody who's here to all of his articles. They're really good. And in my opinion, he may very well be the foremost expert in this field on a national level, along with, of course, any corporate law professors who are in the audience tonight. Next, we'll hear from E. Powell Miller, also known as Onus, because he is one of the few to own that famous baseball card that we used to read about when we were kids in baseball card journals. Honus Wagner, the baseball player on that card. He's an interesting guy. The reason his card is so rare is because he was adamantly against tobacco. In those days, it wasn't bubble gum. He refused to license his image to the tobacco companies. But what I found most noteworthy about him when I was researching him at one point was that he was very tough, and he actually cut a hole in his glove in order to be able to feel the ball better when he played it in the infield. And the way that he plays ball reminds me of the way that Powell practices law. I've worked for Powell, worked with Powell, and I'm happy that I've never worked against him, I'll admit, because he doesn't lose. He's undefeated in trial and arbitrations, many of which involve the subject matter which brings us here today. And in fact, he just secured a no cause out in California in a very high-profile and high-stakes case. Dan Quick from Dickinson and Wright will be on the mic next. Over the years, I've enjoyed Dan's articles on how the statute needs to be reined in because the minority is becoming almost more powerful in many ways than the majority with the remedies that the minority can threaten under the statute. And I think he would argue, and will argue, that this isn't necessarily good for business because a minority shareholder should know his or her place, and it should be consistent with the corporate governance documents that established the entity in the first place. Setting that aside, there's often a problem, as we see in the fact pattern here, where those documents aren't exactly the model of clarity, which creates a lot of issues that are interesting to talk about. So I hope he doesn't convince the legislature to rein it in, because I like these cases, and I don't want it to go the way of the no-fault statute. And finally, Judge Lepopki from the Wayne County Business Court is going to give us a perspective from the bench. And sometimes it can be a little scary since these perspectives are of all of you and me, but it'll be good for us to hear. Because really, is there anything more important in what we do than how we're perceived by the judiciary and our arguments and how we present them and how we manage our cases and our documents. So Bernie Fuse from Butts Along, he was going to be here tonight, but he had the misfortune of planning a trip to Puerto Rico at the same time there was a colossal earthquake a few weeks ago, so needless to say, he was a little bit shaken up. Wow, bad joke. But we will seriously miss him. He's doing well, he's a great lawyer and a great basketball player, and we'll look forward to him speaking next year, hopefully, when we do this program again. So again, we invite audience participation. We got the mic, don't be shy. So this is the moment you've all been waiting for. It's when I sit down and be quiet for a little while. And Doug?
Well, thank you, Mark, and good evening to all of you. As Mark mentioned, I am a law professor at the University of Houston. Since I have been here, everyone from the thrifty car rental agent to my waiter has asked me about the Astros. I'm hoping you all will not ask me about the Astros. But I've been a law professor there since 1997, and much of my research has focused on minority owner rights in closely held businesses. And in particular, I have focused on the shareholder oppression doctrine. And so you can imagine my delight when I think I got an email from Mark out of the blue, and he said they were actually doing a seminar, conference, on oppression. And I thought, well, fascinating, because Michigan, as some of you undoubtedly know, if not all of you, has had somewhat of an explosion in oppression cases, both in the corporate setting and in the LLC setting, over the past 10 or 15 years. And so again, very happy to be here, and thank you, Mark, and anyone else who invited me. Here's what I'd like to do with y'all over the next 20 or 25 minutes. I would like to really go over some of the basics, some of the background on what's a closely held corporation, what's the oppression doctrine, so that we all have sort of a common foundation we can launch off with for the rest of the evening here. Now, I have no doubt that some of you are well aware of this stuff, but it's amorphous enough where a little bit of a review, I would hope, won't hurt anybody. The other thing I'd like to do with my time is I'd really like to try to situate where Michigan sits in certainly what I view as kind of the national landscape of shareholder oppression law. So I'd like to try to accomplish that as well. I should tell you I am in love with PowerPoint transitions and can't seem to stop myself from using them. So some of them are very annoying and time-consuming, but there's not too many slides. So at any rate, let's start with, what in the world is a closely held corporation? And by the way, this is important because this is where the shareholder oppression doctrine comes from. I mean, the doctrine is actually born out of the closely held corporation setting and the constraints that are in that setting. So it's actually important that we understand what this is. It's usually defined by its characteristics. And so you see on the slide here, most courts define a closely held corporation as having a small number of owners and substantial shareholder, that's what we call the owners obviously, substantial owner participation in the management of the corporation, as well as probably the most defining element, the absence of any market for the company's stock. Now, let me just sort of unpack those elements a little bit. If we go back to the first one on a small number of owners, if you think about corporations on a spectrum, right, most of us typically think, maybe not most of us in this room, but I would say most people typically think about this end of the spectrum. This is the publicly held corporation, right? This is Apple. This is a company that has thousands of shareholders, where those shareholders largely are investing with financial expectations, and that's about it. Okay, but we are way down here on the other end of the spectrum. Closely held corporations think of as small number of owners, often family corporations, 30 or less shareholders frequently. It doesn't have to be, but just to orient yourself, we're way down here. Often much more unsophisticated, often, as Mark alluded to, not very lawyered up at the beginning of the business, so you often don't have a lot of well-drafted agreements if you have any. Okay, that's sort of where we're living, basically, for this evening. This second element is actually, to me, a very big difference between the closely held corporation and the public corporation. And probably the easiest way to say it is, as we're all probably aware, if you are an investor in a public corporation, you're not contributing any labor to the company. I mean, you're not participating in management either. You are a classic passive investor, right? You invest your money and you hope to get a financial return on that money, either through capital appreciation or dividends or both, right? And we would think it was funny. We would truly think it was funny if you thought, oh, hey, I invested in Apple, I expect to have some kind of entitlement to a job. We would think that was comical. And we would think it was even funnier if you said, oh, I invested in Apple, I think I have some entitlement to a board position. I mean, that would be hilarious. Okay? But it's very different in the closely held corporation. In the typical, and I want to emphasize that word, because not always, but in the typical closely held corporation, shareholders do expect both employment and a management role in the company, usually as a board member, as well as the financial expectations that I think every shareholder in any size corporation expects. But those participatory expectations are very important for closely held corporations because it's a big difference with the public corporations. And so again, when I say participatory expectations, what I'm trying to drive home is that the typical closely held corporation shareholder thinks of employment and a board role as part of their return on investment, as part of what they're getting for contributing to this particular company. And we'll talk more about that in just a moment. This last element, absence of a significant market for the company's stock, quite frankly, to me, that's really the only element. I mean, that element alone, even if you did have a large number of owners, and even if they did not all participate or most participate in the management of the business, I would tell you, as well as many authorities, that what really defines a closely held corporation is that there's no market. There is no market exit. And so that is probably the defining element of a closely held corporation. If you feel like you've been treated unfairly or abusively by those in control of the company and you're in a public company, well, you just sell it, right? You sell your stock, you recover your investment, you move on down the road to whatever other productive use you've got for that money. But by definition, in the closely held corporation, there is no market exit. Okay, so at least some basics on just what in the world a closely... Look at that. See, it just thankful. It just takes forever, that's the problem. But at any rate, so that's what a closely held corporation is. Now, so who cares? So what exactly is the problem? Well, the problem is pretty easy to understand once you understand where the power lies in a corporation. And so traditionally, most corporate power is centralized in the hands of the board of directors, right? In fact, by statute, in every state in this country, the management power of the corporation is given to the board of directors, at least in the default setting of the corporation. Okay? And so just think about it the way that first bullet point reads. The board controls the corporation. The board by statute has the management power in the company. And so then the question becomes, well, who gets to pick the board members? Because obviously if you control the majority of the board and the board controls the company, you're basically controlling the company. And the short answer to that question of who picks the board members is it's the majority shareholder, or the group of shareholders that together comprise the majority ownership group. And in fact, the way traditional corporate law works is that if you are a majority shareholder or a member of the majority shareholder group, you actually have the voting power. If we don't have cumulative voting in play, which we usually do not, you have the power to elect not just the majority of the board, but the entirety of the board. Okay, so if we get to this third bullet point here, if you're the majority owner who can elect all of the board and the board controls the corporation, pretty much you are in control. And you have the power, therefore, to take unjustified actions, if you wish, by using your control that can harm the minority shareholder. And we sort of generically refer to that type of conduct as oppression or oppressive conduct. When the majority uses its control in an unjustified manner, in a way that harms a minority shareholder, or perhaps more than one minority shareholder. And the classic oppression, the sort of, again, it doesn't have to be, but the classic oppressive freeze-out is when you deny the minority shareholder not just the financial rights, but also those participatory rights that we've been talking about. Okay, so just some examples here of case law throughout the country. Examples of oppressive conduct. Terminating the employment of a minority shareholder is a big one in almost every jurisdiction. We'll talk about how Michigan handles that in just a moment. Removing minority owners from management positions like board positions. We'll talk about whether that is even relevant in Michigan. I don't think it is. But I would tell you nationally, that's a big one. Refusing to declare dividends, another big one. Blocking access to information. You heard Mark talk about this a little bit. Draining earnings of the company through inflated salaries or bonuses where I'm not cutting the minority shareholder in to his or her or its proportionate share of that money. That's very common. And again, the real problem here is there's no exit, right? By definition, there is no market exit. And so it's that sort of architecture of the closely held corporation in the default setting that creates this oppression problem. You really are stuck in a very literal way, again, in the absence of you contracting for some solution. So I mean in the default setting, this is the problem with the closely held corporation. By the way, we wouldn't care about the lack of a market if there was some other way to cash out of a closely held corporation. So for example, there was a default rule in the state's governance that said a minority shareholder could basically demand a buyout whenever the minority shareholder wishes. We have something like that actually in the partnership form of business, but no state's corporate law provides that right as a default matter in the corporation. So you really are stuck, and that's important, in a very literal way, again, in the absence of some sort of contractual solution. Okay, so let's talk about nationally what has occurred. And so before we start focusing on this slide, I should have made a slide on this, but pretend like we're making a little organizational chart here. And the little rectangle right at the top, this is the oppression problem. Okay, and then we got two branches coming off that oppression problem. One branch is what most states in this country have done. And most states in this country have said, we are going to create some special common law rules, often aided by statute, but nonetheless some special common law rules to help protect minority shareholders from this oppression problem. The other branch is exactly the opposite. There are some states in this country that have said, we are not creating any special common law rules to help minority shareholders and closely held corporations. Yes, they can use contract. Yes, they can use traditional corporate law principles, fiduciary duty, derivative lawsuits, etc. But we're not coming up with any sort of special protections for them. Okay? The only reason I raised that branch, it's a very few states, but Delaware is one of them. And we can talk about that maybe later this evening, that Delaware has a Supreme Court case where they have explicitly said, that's it, we're not coming up with any special rules for closely held corporation shareholders. Okay, but what I want to talk about now and what this slide is governing is this side of our little diagram here. Most states in the country have said, no, we're going to come up with some special common law rules. And of those states, the protection sort of breaks down into two different approaches. The first is what you see as that underline at the top, what I like to call the statutory action for oppression. So approximately 40 states in this country have a statute that allows a minority shareholder to come into court. It's a judicial dissolution statute normally. And it allows a minority shareholder to come into court and to petition for dissolution of the company on the grounds of oppressive conduct by directors or those in control. Okay, and I should point out to you that even though that ground is often in a dissolution statute, in almost all of those 40 states, with the exception of Virginia and one other state, the courts have said, ruled, decided that they have discretion that if they find oppressive conduct, they don't have to order dissolution. Sometimes that discretion is given to the courts, like we're about to see in Michigan, in the statute itself. But oftentimes, courts simply say something along the lines of, if the legislature gave us the power to dissolve the company, surely we have the power to do something as like a lesser included power to do something less drastic than dissolution if we think that that will remedy the problem. Okay, so what I want you to sort of keep in your head is that even though these are in dissolution statutes, the court does not have to grant dissolution, and quite frankly, rarely does. The number one remedy for oppression, I would tell you, in this country is a buyout of the oppressed shareholder's ownership position at a judicially determined fair value, which is a whole other can of worms, which we should talk about as well. Okay, now, if you've got statutes saying you can dissolve or give some less drastic remedy on the grounds of oppressive conduct, the courts have to figure out, well, what the heck is oppressive conduct, right? And so I want to just point out these two definitions because, well, largely because Michigan doesn't do either of them. But I want to tell you that there are two principal definitions of oppression nationally. The first is what we call frustration of reasonable expectations. And just very quickly, oppression should begin to arise when the majority's conduct substantially defeats the expectations that objectively viewed were both reasonable under the circumstances and central to the minority's decision to join the venture. Again, this is typically when the majority uses its control in some way to frustrate the reasonable expectations of the minority. I would tell you most states use that as their definition of oppression. But this second definition is also very common. And that second definition, I like to say, is just a lot of words that basically say unfairness. To me, it's like the plaintiff's lawyers, I mean, you know, Mark and others might disagree with me, but I always think that if I was a plaintiff's lawyer, I just want a cause of action that's called unfairness. So that I can just walk into court and say what I always want to say, which is, this is totally unfair. and not have to find something to shoehorn it into. And this is pretty close to an unfairness cause of action. If you look at that second definition of oppression, burdensome, harsh, wrongful conduct, lack of probity and fair dealing, visible departure from the standards of fair dealing and a violation of fair play. I mean, that's a whole lot of words that basically boils down to unfair conduct to the minority is considered oppressive. Okay, so that's about 40 states in the country that have one of those statutes that allow you to petition for dissolution or some other relief on the grounds of oppressive conduct. But if you look at that second underlying approach, mostly states that don't have one of those statutes, but sometimes states even with the statute will also have this approach. But let's talk about states that don't have a dissolution statute. A number of those states have decided as a matter of common law that the way they're going to remedy oppressive conduct is by imposing a fiduciary duty that runs not to the corporation, which traditional corporate law already establishes, but it's a fiduciary duty that runs from shareholder to individual shareholder in a closely held corporation. Some states even say it runs from the director and the officers to individual shareholders. And it creates, therefore, a direct cause of action that a shareholder can bring for breach of fiduciary duty to that shareholder, not to the company, to that shareholder. Massachusetts is probably the leading jurisdiction of that approach, oppression as a breach of fiduciary duty. A quick law professor point here. Obviously, I assume that most of us in the room, if not all of you, are lawyers, so you do have to care about the doctrinal differences between the statutory approach and the fiduciary duty approach, but I just want to say that, from the 20,000-foot view, these are really two sides of the same coin. These are just states saying, we got to come up with some special rules to protect against oppressive conduct, and how are we going to articulate those special rules? Well, we'll do it either through statutes or we'll do it through breach of fiduciary duty. Okay, but they're really just two attempts to try to tackle the oppression problem. I mean, look at that one. The birth, right? How can I not do that? Okay, so let's talk about Michigan. So Michigan has, so first of all, Michigan is clearly in that first camp of 40 or so states that have what I'm calling a statutory oppression action. Now, Michigan's got one of these statutes in the corporation statutes. This is what I've got up, 450.1489. They have a similar, although not identical, provision in the LLC statutes. So very briefly, because this is long, let me just try to break the statute down for you. So subsection 1 is really where the heart of this is, and I'm just going to read the blue there. A shareholder may bring an action to establish that the acts of the directors or those in control are illegal, so that's a ground that's in the statute, but that's not our focus this evening, fraudulent, another ground, or willfully unfair and oppressive. That's obviously the key language for us. To the corporation or to the shareholder, which I want to say some words about in a little bit. Okay, but that's really the heart of the statute, right? And that's very similar to 40 other states that say you can come into court, ask for relief on the grounds of, in Michigan, willfully unfair and oppressive conduct to you as a shareholder. A, B, C, D, E, F is very interesting because Michigan codifies that remedial discretion that I mentioned. Well, to codify it, it's in the statute, right? I was going to say they codify it in the statute, but that's what you codify means. So it's in the statute. The court doesn't have to guess whether it has any equitable discretion, although again, I think most courts come to that conclusion. It's in the statute. And I just want to call your attention to E. One of the remedies that's mentioned in the statute is the buyout. The buyout at, quote, fair value. Again, two words that have sort of launched another 100 cases about what that means. Paragraph 2 of the statute says this oppression action is for closely held corporations. If you're in a public company, don't clutter the courts with your action, just sell. You've got a built-in market, just go away. This is for closely held companies. And paragraph 3, which I want to talk about in a moment, actually defines in the statute what is meant by willfully unfair and oppressive conduct. And let's start talking about that. So a couple of things that jump out at me when I look at the Michigan statute, and from looking at some of the slides of my fellow panelists, it looks like some of this stuff we probably will be talking about this evening. So first of all, let's talk about the definition of oppression. And I think, is this the right slide? Yes. So this is paragraph 3 that we just looked at, but just a little, I guess I didn't need to make it bigger, but a little bit bigger. So if you look at the first paragraph, Michigan is unique in that I do not know of any other state, and I want to say I've looked, that defines oppression in the statute. Okay, so Michigan says willfully unfair and oppressive conduct means a continuing course of conduct or a significant action or series of actions that substantially interferes with the interests of the shareholder as a shareholder. Now, first thing I just want to say is, again, just as an observation, I don't think there's any other state that defines oppression as a matter of the statute. But also what's interesting to me is that Michigan does not follow that reasonable expectations approach. Michigan does not follow that burdensome, harsh, and wrongful unfairness definition. Michigan literally has created its own definition of oppressive conduct. Now, we could all argue that these are general enough that they all boil down to the same thing anyway, but putting that aside, I do think that it is harder in Michigan to analogize to precedents in other states that have confronted issues of oppression, because at least there's always the argument of the definition of oppression is different. Now again, I don't know how significant of a difference it is, but I just want to point out as an observation that Michigan has decided to sort of go its own way in terms of defining oppression. I know of no other state, again, that defines it in the statute or that defines it like that. Okay, but more importantly, look at that language in the first paragraph again, that interferes with the interests of the shareholder as a shareholder. This again is unique to Michigan. In fact, I would say this is diametrically opposed to other statutes that explicitly state oppression can be to a shareholder in his or her or its capacity as a shareholder, as an employee, as a director. Michigan says as a shareholder. And as many of you are probably aware, we've got case law in Michigan that, as far as I know, started with that Franchino case, where the court said, look, Michigan says we're only protecting you as a shareholder. What does that mean? It means we protect traditional shareholder rights. Things like dividends, things like your voting rights, things like your inspection rights. But employment's not a traditional shareholder right. And being a director is not a traditional shareholder right. So that's not protected by the oppression doctrine. I would tell you that is very, very different from, quite frankly, any other state that recognizes the oppression doctrine, where terminations of employment and being removed from a director position are, I think, two of the big three oppression allegations that you typically see. Now, Michigan, of course, amended their statute. And if you look at that second paragraph, I think it was, well, it was definitely after Franchino. Some other folks probably know specifically the date better than I do. But look at that second paragraph. Willfully unfair and oppressive conduct may include the termination of employment. Okay, so we built that back in. Or limitations on employment benefits to the extent that the actions interfere with distributions or other shareholder interests disproportionately as to the affected shareholder. Now let me just point out, particularly because I'm running out of time here, I don't think that provision builds back in protection for employment as a participatory right. What that provision seems to say on its face is that to the extent employment affects your financial rights, because it is true that in a number of closely held corporations, employment is often the vehicle for distributing profits, because you can get a tax deduction if you call it employment compensation, if it's not an S corporation, but you can't if you call it a dividend. So it's very common that corporations will disguise what really is a dividend payment as employment compensation. And so that makes sense, that if you get fired when employment is the vehicle for receiving dividends, that's hurting your financial rights. That clearly, that language protects that. I'm not sure that language does anything, though, for employment if it's merely a participatory interest and doesn't have a financial component. And let me just point out, there's nothing there about a board of director position. Board of director position is not employment. Board of director positions are, you're literally, you're a contractor. You're not an employee. Unless you are an employee because you work for the company in some other capacity, a director by itself is not an employment position. Okay, I've already gone over. Let me say one last thing and then I'll stop talking. Oh yes, this language on oppression to the corporation. Michigan, I think, is also unique in this aspect. I have not seen this in any other statute that it says you can have oppressive conduct to the corporation or to the shareholder. I must confess, I don't even fully understand what oppression to the corporation means, because the oppression doctrine was not a doctrine that was ever developed about corporate harm. It's about harm to the individual shareholder. Now, what's interesting about this, here's my crackpot theory, which you can feel free to reject. Remember, this statute also covers illegal and fraudulent conduct. That is often to the corporation. My suspicion is that perhaps that language was meant to apply to those grounds and not necessarily to oppression. But whether you agree with that or not, it is definitely the case that that language has been significant in Michigan cases for the following problem, and then I promise I will stop talking. Many jurisdictions confront the following problem. What happens if the majority does bad things that hurt the corporation and only indirectly hurt the shareholder because the shareholder is an owner? Things that you would normally bring a derivative lawsuit for in the fiduciary duty context. Can you bring a direct oppression action as an individual minority shareholder based on harm to the corporation, and that's only indirectly to you? And there are Michigan cases that, of course, point to this language and say, well, it appears that you can, because the statute says oppression to the corporation counts as oppression. I personally have never seen that anywhere else, although I don't think that result is necessarily surprising, but usually jurisdictions reach it in a different way. Okay, well, at any rate, I'm well past my time. Thank you all very much, and I'm sure we will have time to discuss some or all of these issues as we proceed.
Moving right along. And I think that one of the last points you made about the harm to the corporation, I find that interesting that that's unique to our jurisdiction. And I have found in pleading these cases, sometimes if you're having a little bit of difficulty showing that the harm actually flowed directly through to the shareholder, pleading the harm to the corporation does expand the pleading somewhat. It's quite a useful pleading technique. So next up is Hal. I changed the order a couple of times, so. Hal's going to tell us how to litigate these cases.
Thank you very much, Mark. Mark started his career with me. He flew the coop and built his own firm. And I am very proud of Mark because he unquestionably has one of the top shareholder oppression practices in Michigan. I strongly urge all of you, if you've got a shareholder oppression matter or question, don't call Sam, call Mark. I couldn't help but think while Professor Mull was doing his outstanding presentation that the appropriate remedy for the sign stealing scandal in Houston was to send JV back to Detroit. So Jimmy's addiction case. So Jimmy comes into my office with the very same 13-page, single-spaced, factual scenario. What do you do if you have that kind of case? I don't know how many of you had a chance to read it yet. I hope you had. If I tried to go through it now, we'd be here for about another hour and a half before I got to the meat of my presentation. If Jimmy came into my client, what would I do? I'd refer him to my worst enemy, as this case would be absolutely a nightmare. But seriously, what do? If Jimmy comes to your office, or someone else comes to your office with an oppression case, I'm going to offer you some perspectives of 33 years of practical experience. So when I face a shareholder oppression case, whether it's a band or a family, my first thought is the same thing that doctors are supposed to do, and not cause any more harm. A band is like a family. And I've had, unfortunately, a case very similar to the Jimmy's Addiction matter. I once represented the Romantics in a shareholder oppression case. And instead of singing what I like about you, we heard a lot of what I don't like about you. And it was a big case. But the first thing I try to do is to keep the band or the family together. And in my experience, sometimes that's hard to do. I've had a number of cases with excellent lawyers on the other side. I see the Hortons here, and when you got a really good lawyer on the other side, that's great because you have a much better chance of keeping a family together and coming to a sensible resolution before it absolutely gets out of control. Unfortunately, like sometimes in marital divorce cases, I think there are a very minority number of lawyers who sadly see it as a billing opportunity and put fuel on the fire. And that's one of the things you have to assess is who is your opponent? What is the dynamic? What is the path to resolution that's cost effective and in the best interest of your client? I've had suits between mothers and daughters, brothers versus brothers, a son versus his mother, a brother versus a sister, and they're awful. But it feels really good when you can resolve them quickly and at least give these families a chance to try to put it back together. One of the things that I think is always most important is to also make sure that you don't unwittingly oppress the client yourself. And I think a big issue that's going to start arising is more scrutiny of attorney fee agreements with clients in shareholder oppression cases. I definitely want to make a buck. I'm profit motivated, just like everybody else. And I think the contingency fee does make sense in the shareholder oppression context, as long as the old adage, pigs get fat, hogs get slaughtered, is kept in mind. Because I think there's a real potential for abuse there. I mean, let's take a situation where a client comes in and says, I haven't gotten a dividend in a couple of years. Can you help me? Lawyer says, sure, here, sign my 1/3 contingency fee case. And in 35 days, negotiates a buyout. And the lawyer ends up with 1/3 of the equity of the client. I think that's a serious problem. I think that's not fair whatsoever. I mean, what did the lawyer really accomplish? Did the lawyer create economic value for the client? Not really. The lawyer liquidated what the client already had and then takes 30%. That's a lot worse off for the client who wasn't getting some dividends. So I think it's a better balance is to have a blend that's maybe a lower percentage, a lower billable hour, or what we do in the class action world, which I do a lot of, is have some type of sensible cross-check, which is some reasonable multiple on the lawyer's time, so it doesn't become a windfall and oppressive to the client. So one of the things that I think should be looked at right away is to be creative, thorough, thoughtful when the client walks in the door. And the first thing that always hits me is I worry about the statute of limitations. In my experience, the statute of limitations has already run on most plaintiffs' claims in shareholder oppressions for at least a part of their damages. Almost every single time. And the reason for that is particularly in family situations, there's a natural reluctance to sue and blow up the family. I mean, I've had situations where, I haven't gotten a dividend in a year, but my brother got a Corvette, They bought a Porsche, and just last week, the reason why I Googled shareholder oppression and I saw you, Powell, so you got a Maybach. Do you think there's something there? I said, yeah. I can guarantee it based upon my experience. But then my mom won't talk to me if I sue my brother. I got to think about it. I always say to them, there's been one cookie eaten, there's been another cookie eaten, there's likely a lot more going on that we got to worry about. The clock has been ticking on your claims. You may have already lost some claims. Make sure you always protect yourself and protect your client by telling them the clock is running, because the clock always is. But on the other hand, like I said at first, can you keep the family together? Can you resolve it quickly? If you run the court too fast, then you're going to add fuel to the fire. You might make it a lot more difficult to resolve the case. So what I really want to do is make sure my client understands it. We talk about striking the right balance, and I want, under that third bullet point, I want to see the contracts, and I want to see the corporate documents immediately. And I'll give you a real-world example that was a nightmare. I had one of these clients come in, and I said, I am very confident that you've been abused probably $10 million or more dollars, and the clock is likely running out. And well, Powell, I'm not ready to do it. I'm not ready to do it. Let me see the corporate docs. Let me see the contracts, please. This goes on for months and months and months. I write letters. It doesn't happen. I happen to go away for a long weekend. I come in on a Sunday, I check the mail, and I find out that at Wednesday late afternoon, the client dropped off all the corporate docs, the shareholder agreement, and I looked through it, and lo and behold, there's a private limitations period. And when did it expire? 48 hours after he dropped it off, that Friday. And I'm like, oh my God, is this my problem? I don't think it's my problem. But, oh my God, it didn't feel good. I think that's when my hair first turned gray. But then I study the contract, and what else do I find? There's a choice of law. Not Michigan. I looked it up. That state does not enforce private limitations, period. So, my hair didn't turn back to brown, but I breathed a sigh of relief. But what I learned from that is you can't assume Michigan law applies. You can't assume it's a 3-year statute of limitations. And you got to lasso your client and make sure they give you those key documents so you can protect the client and avoid any kind of catastrophic mistake. In the Jimmy's addiction matter, I would try very, very hard to get a tolling agreement. I would hope that the other lawyers involved were people like Mark Rossman and Bill Horton and Angela Baldwin and other great lawyers that I have a lot of respect for, and that we would sit in a room and we would recognize that all of our clients are sitting on atom bombs. And that if any of us do anything, we're going to blow each other up to smithereens, and we're going to destroy the golden goose of this company. And I try to get this resolved. I would look at some great mediators out there, folks like Bill Winston, Gina Shockey, Keith Brooks, and many others, and try to put that band back together before it got any worse. And another thing that I think we should all think about, and it's one of my pet peeves, is publicity. I generally think it's a mistake to argue cases in the press, and when a case is resolved. I just had one. A wonderful $23 million, no confidentiality provision. But I don't just put it in Lawyers Weekly, because that could have created problems for my client. They're trying to put their family back together. And then you put it in the papers, and sure, it makes me look good, but it's not so good for the client. So my practice is to meet with the client, talk to my client about it. My client's first reaction was, sure, go ahead, because he was really happy with the work I did. And I said, think about it overnight. He called me back and he said, you know what? Thanks, Powell. I wish you wouldn't do it, because I'm talking to this family member some more, and I hope we can patch it up. And I feel really great that got a very large result for this client, but I didn't do any harm, or no more harm than I had to do to that client. And I truly believe that if we just stay focused on what's in the best interest of our clients, we can do a lot of good, make a lot of money, and have a wonderful practice. Now, Professor Mull did a great job of talking about shareholder oppression. And so I don't want to do overlap, but I want to give you some other ideas that almost always exist in shareholder oppression cases that I think sometimes are missed, and that can be very powerful bombs to drop. One of those is breach of fiduciary duty and diversion of corporate opportunities. Production finishing versus Shields is one of my favorite cases. What happened in that case is the president of production finishing found out that Ford Motor Company was getting out of a certain business. So he thought, this might be good for me to get into. So he took it for himself, not for the company that he was the president of. Eventually, all this came out. It resulted in extensive litigation. And the defendant actually won in the trial court, but it was reversed in the Court of Appeals. And the Court of Appeals held that you owed high duties to your company that you were the president of. You had no right to take this opportunity for yourself. So guess what? All the profits you made, you now disgorged to the company. Reminds me of another case in California where this was a marital divorce, and the wife wins the lottery. Doesn't tell her husband. They get divorced. In the divorce process, it comes out that she did not disclose that she won the lotto. And the judge says, ma'am, I got some bad news for you. You were married at the time you won the lotto, so half of it goes to your husband. Oh, no. But since you didn't disclose it, you breached your fiduciary duty, so he gets your half too. So, breach of fiduciary duty, diversion of a corporate opportunity is a powerful weapon, and I would always keep that in mind. Another bomb is conversion. And while it's often hard to get conversion to stick, don't underestimate it, because it is an atom bomb. Treble damages, attorney's fees. I had a case several years ago, and all confidentiality was waived, so I can talk about it, where I represented Peter Carmanis against CompuWare. They terminated his consulting agreement, and they canceled all of the stock options. And one of our theories was that the stock options were converted because we had extraordinary evidence that the Office of General Counsel had stated to his broker, E-Trade, don't help him with the deadline for him cashing in his options. And I suggest you don't throw yourself under the bus with CompuWare. Our theory was that was an interference with the use and enjoyment of his property. And while it was an unreasoned arbitral award, so we don't know what was in the arbitrator's mind, I think it might have had something to do with the $16.5 million size of that award. And what also strikes me about my experience in that case is the Spencer Perk in the hypothetical example that's provided in your packet about a lawyer who's done questionable things. I have seen that in a number of cases that I've handled where there's been a lawyer involved representing the company or some of the shareholders and has engaged in some sketchy or shady behavior. And that's another powerful angle, because that gives you fiduciary duties, that gives you potentially legal malpractice, and it also gives you wonderful opportunities on cross-examination. In the Carmanis case, and again, all confidentiality was waived, I'll never forget putting the general counsel of CompuWare on the stand and asking him, did he in fact personally represent Peter? Yes. Was it true that Peter was responsible for getting him promoted to general counsel? Yes. Did that result in millions of dollars in compensation? Yes. Did he understand that when Peter was leaving and Mr. Paul was coming in, that Mr. Paul did not like Peter? Yes. That Mr. Paul urged him to negotiate a different consulting agreement that made it easier to fire Peter? Yes, he admits that. And also admitted, did he in fact tell Peter that the only change in the agreement was that he could be fired if he committed a major felony? He said yes, he told him that before he signed it. When I asked him, was that truthful? He said, no, it wasn't. So I said, so what you did is you robbed Peter to pay Paul, right? And what also happened there is, and I just give you the very, very short part of it, but he was brutalized with cross-examination from the Michigan Rules of Professional Responsibility. So a lawyer hasn't done the right thing. Don't be shy about calling him as a witness and going after him. Again, I thought Professor Wall did a great job explaining shareholder oppression. But one tool to keep in your toolbox is it's very powerful to have the ability to inspect books and records. And sometimes when that client comes in the door, your nose tells you that something is wrong, but you don't necessarily have enough to, in good faith, file a complaint. This is a good way to start, to look at the books and records. And sometimes that can lead to a negotiation early on, before it blows up, and before you get into full-blown litigation. And I thought it might be helpful to end with just some examples of actionable oppression. Actions that prevent minority shareholders from exercising typical shareholder rights, diverting corporate funds to outside companies, misappropriating corporate opportunities, and reducing value of minorities' shareholding interest, hiding corporate profits from minority shareholders, refusing to pay dividends to minority shareholders despite the existence of cash reserves in the corporation, and preventing the shareholder from participating in corporate decisions. These are common. I've seen these recur many, many times. I often say to clients when I hear their story is, unfortunately, I've seen this movie before, and certain patterns develop. And an example is, and I get this, I mean, I've defended these cases, I've prosecuted these cases, probably more often prosecuted them. But what often happens is there's one person who really is driving the success of the company. And they then start believing that they should enjoy more of the fruits of the company. And there's some real legitimacy to that. And they start to resent maybe their brother or sister who has nothing to do with the company, but they both inherited the same amount of stock. And the person who's doing the work decides to take a cookie here, then another cookie, and then they want to take the whole jar. And what I try to do if it's early enough, because I think there's some inherent unfairness that, you know, I think the amount that most cases that I've dealt with, and in fact most experts, I think the amount of salary is a little low for the people who are really the stars in these companies, and I think they should get a higher salary. But the problem is, where do you draw those lines? When does it go too far? And that's the stuff of oppression litigation. But I think some really good advice and counseling can sometimes prevent these problems from getting out of control, and sometimes can prevent litigation. The oppression statute gives the court great discretion and power, which I think is awesome. I mean, I really believe in the discretion of our business courts, and to give these judges a lot of power to help resolve these disputes. And they often lead to buyouts, although that's become you know, a little bit more difficult to force a buyout, but it's often the most logical solution is to have a buyout, everybody moves on. But I do think that with the buyouts, there is a risk of there being some abuse on attorney's fees. And I think we as practitioners, you know, ought to think, you know, about, you know, pigs get fat, hogs get slaughtered. We should be, I mean, I'm not saying that it's wrong to have in my opinion, wrong for a lawyer to have a contingency fee for a buyout at all. I just think that it should be measured with some judgment. And I love these cases, that it's a very exciting area of the law. But what I would really urge everybody to do is, if I had to sum up, I'd say the statute of limitations is almost always a problem. Deal with that in the very first inning of the case. And don't lose sight of the power of common law fiduciary duty. I've rarely seen that production finishing case cited. I think it's a very powerful weapon, and it may be only 10% of the time that you can get conversion to fit your facts. But when it does, it's very powerful. Thank you.
Well, thank you very much. I think you offered some wonderful insights there. And I was glad to hear you discuss the statute of limitations, because that is a serious issue in these cases, because the statute provides a 2 to 3 year period of limitations depending on the circumstances. That's short. And in the Frank v. Linkner case, the court held that the claims could be fraudulent or told by fraudulent concealment, but that's a tough standard to meet. And in fact, in that case, the Frank v. Linkner case, when it was remanded to the trial court after that climb up the ladder, and the court held that you have fraudulent, that the plaintiff had fraudulent concealment argued, the record shows that the case was voluntarily dismissed quite quickly after it was remanded, which might emphasize how difficult a litigator may perceive it to be, but to succeed on a fraudulent concealment argument. So get those tolling agreements and cover yourself on the statute of limitations. So thank you, Powell. Dan? Like I said, Dan's going to explain to us how this has gone a little bit too far in certain respects.
Good evening, everybody. It's my pleasure to be here as part of this symposium. I'd like to thank, of course, the State Bar, Wayne State, and Mark in particular for putting this together. It takes a lot of effort to do this, and I hope you're finding it valuable. My role here is a little bit of kabuki. I am playing the contrarian on behalf of the majority. Some of it, I believe, in fact, most of it, but I'm going to play a little bit of a role here to make a point. In reality, like Powell, I often litigate these as a plaintiff as much as I am the defendant. In fact, Powell and I had a case not too long ago where I was representing the poor victim minority shareholder, and Powell was representing the evil majority oppressor, which we were able to successfully resolve. So while part of this is a role, part of this does really bug me. And as we'll talk about, it bugs me on a couple levels. One is it bugs me doctrinally in terms of thinking about the oppression remedy within the overall statute structure of the Michigan Business Corporation Act. And it bugs me on a practical level in terms of how it actually plays out in the courts, the imposition it puts on these businesses and the people who own them, and the families who own them, and ought it really be that way? So my thesis, for purposes of tonight's discussion, is that it has gone too far. That the case law has gone too far, and that the practical effect has gone too far. And on both the substantive and on a procedural level, we need to think about ways to swing the pendulum back to some degree. And then also, we're going to talk briefly about some trends in the case law, some ways to manage litigation through use of the Michigan court rules, and lastly, some statutory ideas that are bubbling out there in terms of potential reforms. So, a little bit of context. And this is going to sound very wonky. The professor will appreciate it, I'm sure, because this is what he does. But for the rest of you, hang with me for a few minutes. Before oppression arose as a cause of action, there's traditional fiduciary duty case law. And that traditional case law started imposing restrictions on a shareholder's right to assert a cause of action. It imposes restrictions in a number of ways. It imposed it in terms of to whom the duty was owed. So if somebody who is in charge of the corporation is paying himself or herself too much money, is that a breach of fiduciary duty to the corporation? Is it a breach of fiduciary duty directly to the other shareholders? And what standing do they have to try to pursue those causes of action? There was also the issue of how such a claim could be asserted, and hence statutes and rules grew up around the assertion of a derivative demand, requiring that litigation not commence until the corporation has the opportunity to consider the demand, and then an opportunity for the corporation to eliminate the claim altogether if it does things the right way, and ultimately comes to the conclusion that it's not in the best interest of the corporation for the plaintiff to pursue that claim. And then breaks evolved in terms of when the court should get involved in terms of trumping business owners. Because at the end of the day, with all due respect to our fine judicial officer, business people tend to take the position that they know a heck of a lot more than any old judge about how to run their business, what ought to be made, who ought to get paid, what role people ought to have, etc., etc. And the judiciary evolved a certain hesitancy, generally encapsulated in the business judgment rule, to start telling businesses from the bench how to run their business out of, in part, a very basic respect for the reality that judges ain't business people, and businesses ought to be permitted to run themselves. So these procedures evolved at a couple levels. At a first level, there's a procedural block. So this case law grew up around direct versus derivative standing. Most claims, back in the old day, really were derivative claims. The plaintiff shareholder, most of the time, could not demonstrate that they really had standing to assert a direct claim. And if it was a derivative claim, then there was these procedures in place in terms of making the demand, having to wait for the corporation to act, and of course the ability of the corporation to do it. These procedures did basically flow out of the business judgment rule and this judicial hesitancy to get sucked into business affairs. And it also grew out of the basic fact that businesses like certainty. When you think about the UCC, and I'm not old enough to bet around when the UCC was first adopted, but one of the basic reasons for its adoption was to grant certainty in the economic sphere. Because right, wrong, or indifferent, businesses want to be able to know how an outcome is going to result from a particular set of circumstances. And if they don't have that uncertainty, it's generally perceived to be a drag on business. So this procedural level evolved, the substantive level evolved in terms of the application of the business judgment rule. And then on top of all of that, there was an additional hurdle, if you want to put it that way, for the plaintiffs to overcome. And this was, I think, a recognition by the bench writ large that these lawsuits, if you let them go, are time-consuming, nasty, and take a very long time to resolve. You know, the old saying that 10% of the cases take up 90% of the judge's time applies in spades to shareholder suppression litigation for many of the reasons that Powell and others talked about. There's a lot of emotion, and they can get out of hand very quickly. So, 1989 was the big year. How the heck did we get here? On one hand, you have the adoption of MCL 450.1489, which basically takes the dissolution provision of law out of the dissolution section of the Michigan Business Corporation Act, moves it up into Chapter 400, and the commentary and the statutory language at the time notes that it wasn't really intended to change the statute. It wasn't intended to change the standard. It did give the court more discretion in terms of what remedy to elect. It used to be all or nothing. Dissolve or not dissolve. Now you've got more tools in the toolbox. But it wasn't designed to change the standard, to actually demonstrate oppression. And at the same time that that statute was adopted, there were wide sweeping updates of all the derivative litigation provisions of the Michigan Business Corporation Act, borrowing from the most current version of the Model Business Corporation Act. And so what did that do? So one of the things it did was adopt what's called the universal demand requirement. So in Delaware, for example, if you're a shareholder and you are in a position where you want to make a derivative demand, if you can prove that it's futile, you don't have to make the demand, you can just go off and sue them on day one. The Model Business Corporation Act in Michigan adopted the universal demand requirement. There are no exceptions. Thou shalt make the demand. Thou shalt wait 90 days before you then sue in order to give the corporation time to deal with that demand. And then the Act adopted various means by which the corporation could deal with it, including in the close corporation context. So if I have disinterested directors on my board and you make a shareholder demand, those disinterested directors can deal with that demand. Well, if it's a closed corporation, maybe I don't have any disinterested directors. Well, the statute says the court can actually appoint a disinterested person to operate essentially as a special litigation committee on behalf of the entity to make this decision about, is it in the best interest of the corporation to move forward with this litigation? And that is the standard. If you look at the Consumers Edison case out of the Western District of Michigan back in the late 80s, early 90s, it borrowed from a lot of other jurisdictions in talking about the standard. But that's really the decision. The business judgment rule applies not just to do we make bricks or do we make bats, but it also applies to, is it in the best interest of the corporation to actually sue my executive or sue my majority shareholder for alleged wrongdoing? And the standard is that the corporation could reasonably come to the conclusion that even though that person did something wrong or likely did something wrong, for my business in this context at this time, it is not in my best interest to go break that person over the coals and sue them in court. And that was how the business judgment rules applied in these contexts. Interestingly, at this time in 1989, there is no Close Corporation Act adopted in the state of Michigan. So the derivative demand applies to a two-person corporation. And there's case law in Michigan, albeit old, saying exactly that. Other states have adopted specific subsections of their Corporations Act dealing with so-called close corporations and setting up certain rules and defining what a close corporation is. Michigan did not do that. And Michigan did not do anything to abrogate the basic concept of buyer beware. And this starts getting into various permutations of this, but if you become a minority shareholder, buyer beware. You understand you're a minority shareholder. If you're worried about having buy-sell rights, then negotiate for buy-sell rights up front, or don't invest in the company and participate in the potential outcome. Not everyone's in a situation to do that. Some family members inherit their shares, but nothing in the Act revisions try to upset that basic principle. And there's nothing in the Act provisions that suggests that a shareholder's subjective beliefs as to what their expectations might be, however ignorant, however uninformed, however unrealistic, should somehow now become the standard by which corporations have to treat them. All of that resonated immediately with a resounding thud. Absolutely nothing happened when these statutes were adopted in 1989. That is because most people didn't perceive this as a sea change. They didn't even really perceive the statute as raising a new cause of action. It was what the commentary said it was. It was existing law, we just took it from this chapter, and we moved it over to this chapter. And in fact, when the Court of Appeals in Bax first looked at the statute in 1998 in any substance, 11 years later, they said the same thing. It's not even a different cause of action. It's all just within the general rubric of our existing fiduciary duty case law. So then a few things happened. The statute was amended in 2001 to adopt this definition of willfully unfair and oppressive. And that started a lot of gears turning. And then the big breakthrough came in 2002 when in Estes 2, the court overruled Bax and said, no, it's a direct cause of action. It's specifically designed to deal with shareholder oppression. Have at it. The next step was, okay, now we have this brand new cause of action. It's out there. What the heck do we do with it? Well, again, originally it was construed construed very strictly. Franchino, applying this language about shareholder rights as a shareholder, the court took a strict constructionist view of the statute, talked about what those limited shareholder rights were, and in that context held employment ain't a shareholder right, goodbye plaintiff. The statute was modified, as we heard, in 2006, basically overruling Franchino, but it did more than overrule Franchino in the real world, at least my perception as a litigator. What it did was change the paradigm by which shareholder rights are evaluated. As opposed to this narrow construct of shareholder rights as a shareholder, and thinking about let's define what those are, what's in the circle, and all the other things that are probably outside the circle. Rather, what it did is it set up this unfairness concept. And it bolded the language on the screen that it is, and this is a reference with regards to distribution, but it became, frankly, the norm throughout the shareholder oppression case law, or other shareholder interests disproportionately to the affected shareholder. So it basically became a normative standard of, if I'm a shareholder and in any way, shape, or form, some other shareholder in that entity is somehow getting more cookies than I'm getting, well, that's unfair, and I'm being oppressed. This was then driven home by a couple cases, one of which is Bromley, which is an unpublished case in the Eastern District of Michigan. I'll get to unpublished cases in a few minutes. But this is the case that applied the language in the statute that said an act can be oppressive if it's oppressive to the shareholder or to the corporation. So now, under the oppression statute, even if there is no oppression vis-a-vis a shareholder, if there is an act which is arguably oppressive as to the corporation, you can sue under the statute. Well, what air is left in the room, I would ask you, for our traditional case law? Why would anyone ever file a direct or a derivative shareholder claim if what instead I can do is assert a direct claim under Section 1489, whether I'm harmed, the corporation's harmed, or anybody else is harmed, I can go to court, avoid all that derivative hoo-ha, and just bring somebody through the litigation mill. This is actually exactly what happened. So these are just some basic stats with my very limited social science skills in terms of how just often these phrases are used. So before January the 1st of 2007, cases discussing substantively, this is somewhat of a subjective count, the direct versus derivative dichotomy, when a case would be asserted one way versus the other, is 23. And there's 15 cases, one way or the other, that cite Section 1489. So by that time, it had been in existence for 20 years. Since January of 2007, there's a bunch more cases talking about the shareholder oppression statute. There's 7 dealing with direct versus derivative. And those 7, by the way, are not even substantive cases. Some of them are. A few of them just happen to use the words direct and derivative. I didn't really even try to parse that out. And of those 7, 5 are since Matagula in 2014. We've had sort of a spate of actual judicial decision-making on these issues in the last couple of years. But the punchline is, and I think the professor used the word, there has been an explosion of shareholder litigation because lawyers ain't dumb, and they know there's an easy way versus a hard way. They are going to pursue the easy way. The other thing that has exacerbated this is the issue of unpublished opinions. This is an issue generally, Lisa Fleischer, who's a friend of mine, Judge of the Court of Appeals, would disagree with me on this, but I think that the number of unpublished opinions does a great disservice to our judicial system and, more importantly, us as lawyers trying to do our job. Because the opinions don't perceive the massaging, don't perceive the intellectual rigor necessarily that a fully published opinion would receive, and as a result, there are unpublished cases out there that say almost anything in the world of shareholder oppression. And one of these, for example, I'm not taking a shot at the particular case, but it's used all the time by the plaintiffs, is Berger versus Katz. And this is, I think, a 2011 opinion. It's very pro-minority shareholder discussion on the rights of the shareholders. Was it intended to be that? Was it not necessarily the most careful drafting of the opinion that might have been used if it was a published opinion? Would there have been more of an effort to make it reconcile with other cases that are out there? I don't know, but it gets cited all the time and used heavily, not just by plaintiffs' lawyers, but by the bench in terms of denying any sort of effort to file the dispositive motion on minority shareholder oppression claim. And I'll get to that point in a moment as well. There is also this procedural effect with regard to the case law. And that is that summary disposition is exceedingly rare. Back in the day of Franchino, when there was a lot of analysis up front about, well, is the plaintiff really pleading a claim of the right of a shareholder as a shareholder? Or before the oppression statutes, there would be vibrant motion practice about whether the plaintiff's asserted claim really was a direct claim, or whether, in fact, it should be a derivative claim, and so court dismissed that direct claim for breach of fiduciary duty. In my practice, the reality is it is darn near impossible to get any sort of either early or late summary disposition ruling on a shareholder oppression case. I would cite here the case of Castle versus Shellam, which is out of the Macomb County Business Court. Of course, you all know that there's a database where the business court judges share their opinions, and as a result, they pop up from time to time in the briefing of the trial court. And this is one that takes this broad view that, hey, one must view the entire factual landscape, the totality of circumstances that are occurring before you can possibly make an adjudication as to whether or not there has been oppression. Well, if that's the standard, ladies and gentlemen, no one's ever going to win a C-10 motion. Everything is going to be sent to trial. The result of this, in part, is a timing problem. The Court of Appeals' recent opinion in France demonstrates this. It takes a long time for these cases to go through the system. In the Franks case, it was filed in 2013. There was a summary disposition ruling on liability in 2016. There was a trial as to the appropriate remedy in 2017. It took till 2018 to adjudicate all the remaining of the claims, and it wasn't until September of 2019 that the Court of Appeals issued its ruling on the appeal. So that's a 6 to 7 year time frame. And what is happening to these family businesses during that 6 to 7 year time frame? Every litigation is painful, there's no doubt about it. But businesses are geared to manage a lawsuit that's about whether or not my widget hurt somebody. That's a normal course of business piece of litigation. As opposed to deposing extended family members, going into 20 years of history, upsetting the apple cart in terms of who's running the business, how dividends get distributed, who gets paid what, new claims asserted because things are happening real time, so they keep managing the business, the plaintiffs keep complaining now something else is problematic. It really does take a tremendous toll when these things go over that amount of time. The other big dynamic in these cases is that you see the judges push parties into facilitation, often early and late, and they generally endorse the philosophy that as soon as they get a sense that there's a lot of bad blood between the parties, well, what's the obvious answer? Order a divorce. Well, it's a little cart before the horse, because the remedy of ordering a buyout only occurs after you demonstrate that there has been oppression in the first place. But on a practical level, seeing what is taking place, many judges look, and I believe, consciously or unconsciously, start with buyout remedy. And they drive the parties to that resolution. And when you hand that sort of power now to a minority shareholder who had no right to a buyout in the first place, that's a powerful thing. And by the way, how does the remedy of buyout get decided? The plaintiff shareholder hires a forensic accountant who says the company is worth $97 gajillion. And the majority hires it and says it is worth approximately 12 cents. And if it actually goes to trial, the judge is put in the unenviable situation of trying to play forensic accountant to come up with a value. So there's a certain amount of unpredictability and arbitrariness in that process that is not useful to business, and I would suggest not useful to our court system. So, will the judicial pendulum swing back? Who knows? questions that I pose here are really the core questions, and I contrast Delaware law. I'm running out of time, so I'll skip that. But Delaware law does allow for a version of an oppression claim just within the confines of a traditional breach of fiduciary duty action, but it's much more restrictive than what you see in the other jurisdictions that have an express cause of action. Is there a rule? One of the questions that had been left open was, is there a role for the business judgment rule? Like, this whole oppression case law just completely eliminates the business judgment rule. It's just gone. 100 years of case law, completely irrelevant. Well, Franks actually gave us the answer to this question, and the answer is, yeah, you're right, it's irrelevant. If you prove the elements of oppression, business judgment rule, who cares? It's out the door. And of course, we have no chance for an early adjudication. One of the things that did happen in another jurisdiction that I find interesting is in Texas. Texas had a robust body of minority shareholder oppression case law. And in 2014, the Texas Supreme Court, in an opinion called Ritchie versus Root, basically said, you all been getting it wrong all this time. We're going to take this cause of action that you've all been construing like this and narrow it down back to this. And the court, in its opinion, talks about the fact that the standard for oppression has become such a squishy monster, and that it has led to this litigation that cannot be adjudicated outside of a full trial on the merits, that is not what the legislature intended in Texas, common law intended, in terms of a remedy. So will the courts at some point weigh in? Who knows? What else could be done? First of all, one of the articles that's in your material is an article about these issues in statutory construction. And this is basically just designed to demonstrate that when you look at this beast that is our shareholder oppression case standard, there's a lot of parts to it. There's a lot of parts that are discrete from one another. So it's not good enough that it interferes with a shareholder's rights. It has to substantially interfere. Should that mean something? Or do these words all just get construed into a, is it fair kind of standard? So dealing with the statute in a different way is one possible avenue. Hasn't gotten a lot of traction so far, I would suggest. Well, what about civil procedure? There's a couple options here. The Franks opinion suggests one of them. And that is that in Franks, the court held that this tripartite definition of oppression, fraudulent, illegal, or willfully unfair, blah, 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 essentially means the same thing. And the point was that Franks made was it's all the same general zip code of wrongful activity. Okay, if that's the case, isn't what we're really talking about a species of fraud? And if it's a species of fraud, shouldn't the higher pleading standard be required up front? Now, even if somebody bought this argument, in practice, I'm not sure how much of an impact it would make, because in reality, a good number of shareholder oppression cases actually are pled in excruciating detail for strategic purposes, because the plaintiff wants to write the dramatic narrative up front and have it be the first document. And so if anything, they go on and on and on about things that aren't necessary. So would it really make a difference? I don't know. The other potential tools here are the discovery rules that were revised as of January the 1st. And there's been a whole endless number of seminars separately about those rules. But one of the things that those rules try to drive home is that lawyers and parties need to do more work in their cases up front and have their ducks in a row, both plaintiff and defendant, much earlier in the case than they normally would. So in the mandatory initial disclosures and early case management conferences, there are ways, if you can get your hands around these cases early on, where you may be successful in partnering with your judicial officer or perhaps even opposing counsel to, instead of just having a let's go run a much discovery period where all this family business gets litigated, let's actually stage discovery in some way that maybe saves us some dollars, gets to some of the more important issues first without opening Pandora's box on all of the issues. There are more tools there in the court rules now to do that, but they will only be useful to you as lawyers if you get in front of these cases immediately and you're prepared to have that discussion as part of the early case management conference with your judge. Lastly, I just want to say, I'll make a comment about potential statutory change. Now, of course, we can't even fix the damn roads, so I don't think we're going to fix the damn oppression statute, but there have been discussions about this from time to time. In fact, Justin Klimko is still here, I believe, from the business section of the State Bar, is running a committee right now where we're looking at this. And, you know, I'm a little snippy on the language on the slide, in that this is a committee made up of plaintiff and defense lawyers, and so as a result, nobody agrees on anything, and why would we fix anything at all? Because we can't, there's no consensus. Now, the cake is not fully baked there. There may end up being some changes that do get suggested. And some of the things that have vexed litigators in this area, like what is the definition of fair value under the statute? Does it mean fair market value? Does it mean you can't apply discounts? Have now been answered by the court in the Franks decision. The other thing that is out there, and again, I doubt it would be adopted, but things that other jurisdictions have done, and the professor has referenced it, are building in automatic buyout provisions. So this would be a fundamental remaking of the power structure between minority shareholders and majority shareholders. But Florida, as an example, and I think there's more than one jurisdiction that has this, has a provision that basically says when a plaintiff claims oppression, corporation, you just say, okay, well, thanks very much, I'll buy you out. And there's a formula and a process to do that. And you don't go through any of the oppression litigation, and you just buy them out. Now, that remedy does help with what takes place in the courtroom, but it fundamentally remakes that balance between majority and minority shareholders. It's a good idea, bad idea, that's way above my pay grade, but there are things that can be done on this. So the only thing that is certain in the area of shareholder oppression cases is that it will change, and we will see where it goes. Thank you very much.
Thank you very much, Dan. That was an excellent presentation. I particularly liked the slide on the trend in the appellate courts post Matagula. Speaking of Matagula, Rama Matagula just walked in. If you want to talk to some real walking, living, breathing precedent from the Michigan Supreme Court, my partner Brian and I had the pleasure of representing him in the Supreme Court a few years ago, before that shift in the Court of Appeals happened that Dan spoke about. I thought that the discussion on the derivative versus the direct claim was an important one, because what it shows is there's a trend moving away from the kitchen sink complaint with every single common law theory, every derivative theory that you can think of, because it just makes no sense to plead those derivative claims anymore, because there's all kinds of wonderful defenses to them, because it was designed for a publicly traded company and not a closely held corporation. And just to comment briefly on the Berger v. Katz case, he's right, that is one of the favorite cases of the plaintiff's bar, and I think it's because in that case, the defendant was being challenged for a buyout scheme where obviously he favored himself in it. It was never implemented, and it was actually noted by the court that the evidence, it was described as an inchoate dream. Yet, even though the plan was an inchoate dream, which never got traction, the court ordered a sort of a King Solomon-esque division of the company where one side would offer to buy it for a certain amount and the other side would get to accept or reject. I get confused when I try to explain that one. But it's a very, very interesting case. So this brings us to our final segment. Judge Popke is going to give us the perspectives from the bench here. And this is, last year when Judge Popke spoke, a lot of the audience kind of got involved asking questions, so I think now would be the time if you have some to ask them, and I have a few I might chime in with myself.
Thank you, Mark. That's great, a great way to start. So when I was trying to figure out what I was going to state in that, I thought, wow, what is the role of the court in this whole oppression area of the law? We have nuanced law, we have statutory law, we have common law. We just found out that Michigan is rare in the country in some of the statutes that it has. We know it's factually dependent. We know there are unpublished decisions out there, and I tend to agree that the Court of Appeals needs to give us more to rely on. They need to give me more to rely on, too, as a judge, because we're under a directive that we're not supposed to really consider unpublished decisions, but they don't give us any published decisions to rely on. So it puts the court in a conundrum, too. So from the court's perspective, we're not experts on corporate oppression. I mean, some judges may like to fool you that they are, but you know and I know that we're not, and that you know more about it than we do. You know more about your clients, the corporations, than we do. So we don't want to run your company or your client's company. So what is our role? And when I think about the business court, and I am very thrilled that we have a business court, because I think it provides different opportunities for you as lawyers that the general civil court does not. Because in the business court, we are supposed to be more inclined to help you reach a business resolution to your case. So many people here have been before me, and so they know that when you come in on that early status conference with me, my question to all of you is, take your business or take your litigation hat off, put it on the floor, and put your business hat on. And how are we going to get through this as business lawyers, which I was when I practiced law too? How are we going to get through this as business lawyers and help your clients reach a resolution to your dispute? And that happens as much in an oppression case as it does in a construction case or any other type of case. So that's the approach that I have, and I think that that's the approach that all of you ought to come to the court with. And you have a lot of opportunities, as I echo what Dan said. Now that we have these new discovery rules and apparently a tendency to overplead anyway, you have to know your case when you walk in. Get those initial disclosures out, make them strong, state your client's position in them. And then when you show up for that first conference, come in prepared. Because if you come in and you tell me, Judge, I haven't got corporate records yet, and I need corporate records, and here's a proposed order, and I want corporate records, why haven't they given them to me? And I don't look at your opposing counsel and say, why haven't you given them to them? And you come into that status conference in my court, I think all of you know, you're going to walk out of there with a really substantive order if you're prepared for a substantive order. And these are the types of cases where you can give your clients a clear advantage by coming in prepared with what you want right out of the gate. So if you have an order and a discovery plan with you, that's going to help. Now, one of the things that nobody here has discussed, and I really don't know the answer to this question, we can ask our panel, do these cases allow you to ask me for any early interim rulings? Is there anything you can do right out of the gate that's going to help you? We have the records, that's one thing, but what about, are there situations where you could come in with some kind of affirmative injunctive relief request? Be creative. Could you come in, I don't know if you could, these guys will probably tell you, could you come in and ask me to order a dividend right now, right out of the box? Could you come in and get some type of preliminary relief? And I think you ought to think about that when you're coming in the beginning. Dispositive relief, I tend to agree. I don't see under this case law how anybody's ever going to get dispositive relief from the court, because good lawyers are always going to create questions of fact. We now have intent as an element. We have undefined statutory terms, case law that is just developing. And so how are you going to convince a judge to give you dispositive ruling? However, having said that, I don't necessarily think it's a bad thing for you to file those motions, because there are strategic reasons why you file dispositive motions that really don't have anything to do with whether you're going to win the motion or not win the motion. Again, it's another opportunity for you to educate me, not only about the law that I learned more of in the last week than I've known in the last 5 years. So not only is it an opportunity to educate me, it's an opportunity to educate me about your case. And if you're going to find out what I think when it isn't really going to hurt you. And since we are the triers of fact in your case, and we have so much discretionary power at the end, you want to know what I think because it makes all the difference. I was a divorce judge for 12 years, and it's kind of like being back in that spot again because as the analogy was drawn, where we are the judge and the jury, and what we say ultimately goes. So you want to know what I think. So I think you need to get in front of the judge that you have. You need to find out what he or she thinks about your case. You need to find out what they don't understand about the law so that you can shore that up at the appropriate times. So you're not getting probably dispositive relief. So what can I do? I put you on a good schedule. Like I said, go back to that early conference and come in there with a plan. And we need to know how this plan is going to proceed. We need to control the discovery, make sure things don't get crazy. One of the things I tend to do in all of my cases is have you discuss at the front end what's the minimum amount of discovery that you need in order to be prepared to go to facilitation in front of the many wonderful experienced facilitators that we have in this part of the state. So come in and think, well, I know I have to have these documents. Again, we're back at the early settlement or the early status conference. What are the documents that I need? What are the key depositions? Whose deposition do I have to have in order to be able to go to facilitation? And who do I think is going to be the best facilitator for this particular case? And the lawyers who come in with that information have such an advantage because you throw out a name and you say, I want, Joe Smith to be my facilitator. Everybody else is scrambling, and the judge goes, yeah, he does a good job. I think that'd be a great choice. So it's all about you being proactive. So when you get to the trying, I think another thing that we can do is try and get you to the point, again, where you're going to try and settle your case, because I think we all know they don't get tried very often. As much fun as it would be for all of us to try these cases, I don't think that many are tried. I haven't tried one yet, and I don't know that any of my colleagues in Wayne County have. We need to be thinking about different paths that we can utilize here. Again, so you get to the point, your settlement doesn't work, now you're going to trial. So now what are we going to do? So you've got a judge, and let's be honest, you know it all turns on what judge you've got. What kind of, you have to evaluate and know your judge. Everybody knows that. I'm not telling you anything that we don't all know as lawyers. So you have to evaluate your judge to decide, is this judge going to be good for me, bad for me? The thing that I found that was very interesting in the Franks case was this reference to an advisory jury. Has anybody used an advisory jury? I haven't either, so I don't know exactly what it is. So I don't know whether that's a good thing or a bad thing that you would want to do, but keep your options open. Maybe if you think that your judge doesn't have the particular strengths that you would like to see, maybe that's a case where you ask for an advisory jury. Help the judge along that you think needs help understanding the facts and the law. If you have a strong judge, stick with the judge. So I think these cases have to be very strategically handled by you, and I think that if you do that, the court can be your partner, as Dan suggested, and we can be your partner in getting you to to the end of this case. I think it takes strong judicial involvement, and I think you have to help your judges get there. Thank you.
All right, we got about 10 minutes to ask our panel some questions here. Does anybody have any curiosities or disagreements or?
Well, can I ask the question? I wanted to actually ask the panel the question that I raised in my comments is, do you see any opportunities to ask any court, any judges for some type of early interim relief that can help move the case along?
Yeah, we'll see what Powell says too on this. There certainly is though, because a lot of times the event that triggers the litigation is that something has happened that's extreme. So the person who has worked there for a long time, who counts on that W-2 salary as their only livelihood, has now been unceremoniously tossed out of the company. And so on one hand, that's economic injury, which traditionally doesn't qualify for preliminary injunctive relief. In a very real world sense, though, it completely upsets the status quo and the apple cart. And so certainly parties make efforts to come into court up front. And then I've also seen, and Powell and I had this in our case, where we've had to go to the court in the middle of the case because real world keeps spinning while the litigation is going on, and somebody does something that seems arguably outside of the norm or is additionally improper, and the gist of the relief sought in that case, and that was ordered, was essentially a status quo order. Like, okay, look, conduct business in the normal course, you gotta do what you gotta do, but vis-a-vis each other, let's not try to make it worse while we continue to litigate the case by doing one thing or another.
I mean, my insight there is I usually shy away as plaintiff from seeking any kind of injunctive relief early. I only do it if I really have no choice, because my worry is the standard is so high, you start off with a loss and you lose momentum. I often try to actually bait my opponents to try to seek injunctive relief, and then when they lose, they often overreact to that, and I think sometimes we get favorable deals or agreements because of an overreaction to a loss on an injunction. What I find most effective is if you can get a really good mediator involved early and someone who will stick to it. Too many mediators, hey, it's one and done. If it didn't settle, they just move on to the next case. The star ones never give up. They call back the next day, they call back the next week, and they figure out a way to get it done.
So a lot of the cases that we get in Wayne County are not big cases. They tend to be small cases with the closely held corporations, and you might have just a couple of shareholders that can't even agree on who's got 51, who has 49, maybe they're 50-50. You can't even decide which way is which. And I recently had one where the three of them of the four got together and clearly came over the majority, and so they passed a corporate resolution that moved the other one out and then put one of those guys in as manager. Should I allow that as a judge? Should somebody be able to stop that during the interim? And if they do allow it, because they clearly are allowed to under the documents, do then I let this manager run the show, and do I uphold that corporate decision even though I know they did it because there's no litigation with this guy?
And that is the one of the challenges for the plaintiff in a traditional minority shareholder litigation case is the majority has the ability to win the war of financial attrition. So ironically, to some extent, the fact that these cases can take a long time to adjudicate and get to a resolution can work against the plaintiff, because you better have some treasure in the bank to be able to fight the fight, or else you can get steamrolled by the majority.
That's a great point. I mean, when we're the plaintiff It's the policy in my firm to get to trial as soon as possible, not to adjourn trial dates. And we call it the surge, like, you know, the Afghanistan war. And if there's a trial date, we will bring in whatever additional resources are necessary to try the case, because it's that trial date that will drive resolution.
Do we have a question over there?
Yeah, this is really more of a philosophical question, I guess, so, and I don't think Judge Poppy probably wants to respond to this anyway, but primarily for Professor Moore, lawyers may want to answer too. Philosophically, the question is, should there be a cause of action for oppression in circumstances when there could be a cause of action for breach of fiduciary duty under traditional corporate doctrine? Or alternatively, should oppression be seen as filling the gap when a traditional fiduciary duty approach isn't really going to work because of the circumstances of the closed corporation?
Yeah, I think that's a great question. Let me just say that I want to say the latter to your question. And I really want to say it because I think fundamentally what the oppression doctrine does is that traditional corporate law, particularly fiduciary duties, were designed to protect the company. In the partnership, you've got fiduciary duties that are owed to both the partnership and to individual partners under most of the uniform statutes. Not all, but in the LLC, under the uniform statutes for sure, you've got fiduciary duties that run to the entity and that run to the members. The corporation, you have fiduciary duties that run to the entity only. And so as a consequence, there is this problem of how do you remedy injuries that are to the shareholder directly. And at some level, I've always thought of it as a standing issue, that if there was a jurisdiction that said fiduciary duties run to individual shareholders as well, I don't think we would need the oppression doctrine. You'd already have a vehicle by which you could bring a lawsuit to try to remedy whatever harm there is. So to me, the real value of the oppression doctrine is the latter part of your question. It's a gap filler. It solves this problem of how do we remedy individual harm when traditional fiduciary duty doctrine is focusing on corporate harm.
You know, one of the things we haven't spoken about today is how to prevent these lawsuits. And so, for example, one of a difficult case I had in challenging corporate action was where every year they had their meeting, and every year everybody signed off and ratified all prior corporate conduct. And whenever there was a major transaction that year, people were allowed to look at it, and there was either a waiver signed, a ratification, or better yet, before these major transactions, other shareholders sign off on it. But that function of doing it at the annual meeting can really protect you. And since we haven't touched on it, I'd be curious if there's any prophylactic measures that we see not happening in these cases that could prevent that.
And I'll be real quick because I'm more interested to hear from the people on the ground about this. So, I mean, unquestionably, a buy-sell agreement is, you know, the best thing you could possibly do beforehand. Some sort of contractual document that gives exit rights and is well-defined, etc. The problem is you're getting lawyers involved very early and it's expensive. And for a lot of these businesses that are sort of shoestring kind of businesses, my sense is that that's just a lot of money to get involved with early on. But let me let you all.
The most effective tool in my experience is the release. It's an atom bomb. So when I counsel clients who are on the majority, I think it's a lot more effective than to have an annual ratification. You know, you have releases signed, and those are just so hard to get around. And it's the fastest way to buy peace.
Princess, if you mean at the end of every year, the shareholders waive any rights of any claims?
Not necessarily on a year-to-year basis. I've recommended people do it that way as well, but it's usually been when things start to get a little swirly and somebody's worried, and then figure out some legitimate mechanism to, you know, get the parties in a room, maybe you sweeten the deal a little bit, but let's, you know, buy peace, let's get a release signed. I mean, I do that in my own practice. I mean, my policy is, thank God, I have I think in my entire, I don't think I've ever had one malpractice case against me personally. I think we've only had one in my firm. But if a client, and rarely do we like to ever give discounts, but I think it's a really good practice. If for whatever reason you decide to have a discount, let them get independent counsel and get a release. I just think the release is an atom bomb.
Yeah, and so aside from the practical reality that parties aren't going to hire lawyers, pay lawyers, and sort of pick the scab of that issue up front when everything is all, peachy keen in the halcyon days of the company. The other issue is that there's any number of shareholder litigation or oppression claims out there that exist notwithstanding written documents and shareholder agreements, etc. The statute was designed to, and it includes this language that says basically oppression does not include conduct or actions that are permitted by an agreement. But the way the case law has evolved is that even if I have a right to do something under an agreement, if I do it for an oppressive purpose and as part of some broader scheme in order to screw over the minority, well then that can still constitute oppression. So the reality is that whatever vibrancy existed in that language to say, hey look, if you agree to let them do it, then you agree to let them do it, has sort of been sapped out of the reality of litigating the cases because a good plaintiff lawyer can always come up with this argument that it's being asserted for an improper purpose or a different motivation or as part of a broader scheme of oppression, and so you don't actually get that benefit of the prophylactic agreements.
We've got a question back
Do we have a question? All right.
I'm not sure how often at legal conferences you get to get the N=1 experience. As we say in engineering, I'm Rama Madhula, Madhula Vital, and Brian.
Autographs after?
Hey, you said you guys, when you're starting a band, you're going to call it the Punctilio of Honor, right?
Exactly. Workaday world.
I just wanted to point out that it's very interesting from a strategic framework what the judge had mentioned about the possibility of having injunctive relief. Because just to walk through real quick in 30 seconds, we had 3 shareholders that were all on the board of directors. We had a supermajority provision. Everybody's salary was set to $150,000 a year and couldn't be changed without a 70% supermajority vote. They violated the supermajority provision. Mark and Brian have the famous Let's Screw Rama email that went from the CEO to outside counsel, which was brought up over and over. But essentially, when it comes down to fairness or economic harm, as the other gentleman mentioned, that was exactly their strategy. Because 2007 was the termination. We tried case evaluation. Before that, we tried facilitation and arbitration. And all the way through, they knowingly knew that they were violating the shareholder agreement. They did not pay. And their whole basic theory was, we'll starve them out. And they made sure to pass a corporate resolution to indemnify the defendant's legal expenses and judgment from the corporate kitty. So 36% of the firm that I own went to their legal expense. And we're talking 2007, we went to trial, and we won case evaluation in 2009, we went to trial, we won the pre-trial stuff, we went to the appellate court in 2012, the Supreme Court in 2014, and we finally got a resolution in 2016. So their strategy worked in the sense that that's 9 years, going back to the point that the gentleman made. Yeah, they pulled $1 million out of the company, plus all their legal expenses, and it would have required, and it did require, that I went into, to use the phrase, had the personal treasury to basically pay hundreds of thousands of dollars of legal fees. Now, if there was some mechanism of injunctive relief to say, hey, this was willful, we have this stuff, but if you guys want to work it out, the entire time, we did not want to go through litigation. So this is a business case, let's work out something. But since they had no harm, no economic pressure on them, they just kept pushing and pushing and pushing. And if it said, hey, you got to keep paying Rama what is protected by the shareholder agreement, it's possible we could have resulted years in advance. So if there's something that I could say as an individual, N=1 for what it's worth, is It would be great if something was codified, because I bet you all of the majority shareholders that are going to try this in the future, they would never want to switch positions with the person being oppressed. And they make sure that they get not even the tiniest bit of economic pressure. This is actually good for the courts because I think it was Mark that said it years ago. He said, who takes a business case to trial? And we went to trial in the appeals court, the Supreme Court, because it cost the other side nothing. And it cost an extraordinary amount of economic harm to my side. And if I had economic pressures that I couldn't deal with, they were hoping that I would, for a firm that had $1 million in taxable income, that Stout, Reesius, and Ross had valued at $7.2 million, that we had a buyout offer that was suppressed from the jury of $10 million, they brought in their experts and said, oh, a tech company making $1 million taxable is worth $1 million. The jury actually got a much smaller evaluation of the company. So definitely I would push for some type of temporary relief to, if members of closely held corporations have a higher fiduciary duty to each other, that could come under that. It's their fiduciary duty to keep paying the oppressed until it could be resolved in the courts or outside of the courts. Thank you.
Well, and I think that you shouldn't eliminate the possibility of coming to us. I mean, there's a lot of equity here. There's a lot of fairness principles in this whole area of the law. And I agree with Mr. Magdula that maybe you come and ask. All I can do is say no. But if you present a case to me, I did grant affirmative injunctive relief about 1.5 years ago, and it was the first time I'd ever done it. I actually even called a couple of my friends on the Court of Appeals. I'm like, I've never done this before. I granted affirmative injunctive relief to pay money, and it was upheld. So don't necessarily say, oh, I'll never get some interim relief out of the judge. It's an interesting area. You might not get it, but maybe you will.
Any more questions? Yeah. Down here, in the front.
I have two questions related to the other end of the spectrum, when you get to trial or just above the trial. One is that, when I'm a plaintiff, one of the points of leverage that I have is that on the verge of trial, I say to the defendant's lawyer, I'm going to get a verdict here and it's going to be a buyout, and 21 days later you're going to have to pay it. Franks seems to have said, now there's a lot of options that the judge has, including the imposition of terms, a long-term buyout, appropriate interest rate. Judge, I was wondering, you were saying that you were in the family court for a number of years, and I assume that that's something that happens in family court from time to time. Has anybody had any experience with kind of the change in leverage that, I realize Franks is only about 4 or 5 months old at this point, whether that's changed the leverage at all? And the second thing is that, kind of going to Dan's point, which is one person goes and gets a valuation for $1 billion, the other one gets one for $127.48. I had a judge say, I'm not listening to either one of you, I'm appointing my own expert, and both of you will pay for that. Has anybody had that experience?
Well, that's probably what I would do, because sorting through your two experts and as you learn about valuation, you know that one expert's using valuations that are going to result in a high number, one's using them and will result in a low number. Neither one of them is wrong. So I think that is one of the things I like to discuss in the beginning of the case as well, and you might want to raise that issue at an appropriate time in your case. Maybe you have a valuation done by a neutral. Maybe you take the risk and agree that you're going to be bound by it. Maybe you don't want to do that because it's too risky, and maybe you just agree to have someone value the company for purposes of going to mediation or facilitation, but which isn't going to be introduced at trial. So I think if you think creatively, Bill, there's a lot of things that you can do, but if you want a buyout, I think talking about valuation early on is a good idea.
Have you ever ordered your own expert?
Not in an oppression case, but I've done it in other cases. And I've done both of those things. I've ordered an expert. I did it on a trade secrets case. I picked an expert and I sent them, I had the expert render non-binding opinion. Is that your case? Oh, did you?
How'd that go?
I don't remember how it went, to be honest. I never remember, but it's a good idea.
All right, well, we're 10 minutes over. Does anybody else have a pressing question that they'd like to ask before we roll out of here? No? Okay, well, there's a lot more to talk about. We'll be doing it next year. And I just want to thank Forts Legal, who videotaped this so we can put it online and it can be used as a tool that we use to educate our clients as well as just generally share knowledge. Forts was nice enough to volunteer their time to do this, and we very much appreciate it. They're one of the best in the business when it comes to depositions, forensic discovery, and videotaping things. So thank you all very much for coming tonight, and thank you to all the speakers. Hope to see you next year.
Yeah. Good. Yeah.